So with that, I would ask Ms. Kathleen Hartnett White, if you would please begin opening statements. You have 5 minutes.
Thank you, Chairman Gomert and Ranking Member Dingell and all the members of the subcommittee for the opportunity to testify on what I think is an increasingly important topic. And my testimony will take the angle of really of the use, the development and use of science really in government agencies predominantly. I want to acknowledge my experience as for 6 years chairman of the equivalent of the Texas EPA, which is a very large environmental regulatory agency, which I, as a non-scientist, because of my position as final decision maker, frequently was called upon to assess the robustness and the quality and the credibility of all kinds of science informing what were ultimately final policy decisions. Science is a critical tool in the development and implementation of regulation, but not all science is created equal. I'm going to focus on a single example, of which there could be many. That's a Texas example surrounding the endangered whooping crane, who winters in the lower part of the Guadalupe River Basin. A magnificent species. In the 1940s was thought there were only 15 members left, and now there are 500. And I'm proud that our state agencies and volunteers and the Fish and Wildlife Service are seeing a recovering species. However, a lawsuit has arisen, which I think is an example of how very weak government science could lead to enormous impacts on the state of Texas. An unusual case under the Endangered Species Act. Instead, as is typical with a challenge to Fish and Wildlife Service for failure to list a species or for failure to implement a habitat conservation plan, this lawsuit sues the state of Texas and claims that the actions of the Texas Commission on Environmental Quality, who under state law is in charge of all surface water allocations and water rights, charging that state agency for the take under the terms of the ESA for the killing of 23 whooping cranes in 2008 and 2009, which was a record number. Texas lost at the district court level. What would that mean? That would mean that, according to the judge's ruling, that the Fish and Wildlife Service would really control the state agency's management of surface water. It really would set Texas on a path that we hear a lot about in California, of the Delta smelt. The perceived needs of the species would be a super priority before any human use of surface water in the basin occurred. At the appellate court level, the district court's level ruling was reversed, and now the original plaintiffs have requested a review by the Supreme Court. There were key facts in this, what the judge called core facts in this issue, were the deaths of 23 whooping cranes developed by local Fish and Wildlife Service biologists in their annual population counts. That was considered dispositive to the judge. When the evidentiary record of the district court's ruling was almost complete, Fish and Wildlife issued a report declaring the methodology used for the count of those 23 deaths as, quote, untenable and, quote, indefensible. And there was efforts to submit that evidence along with a very interesting new set of facts, and the judge denied them. So for the lawyers in the room, the district court establishes the facts. The appellate court and the Supreme Court cannot add additional facts. Some very important additional facts, besides the fact that Fish and Wildlife Service has abandoned and really trashed, if you will, the scientific methodology for making these bird counts. In 2008 and 9, the claim was, remember, 23 birds dead, most because were missing when the survey was conducted. They weren't in their usual places. In the next year, when the census was done, these same number, 17 birds, mysteriously reappeared. And that really is a scientific issue. But those facts, that the basis of the count made in 2008 and 2009 at the heart of the case, were in fact factually incorrect. It's one of many examples of how correlation is not necessarily causation. And that, as an issue in science, is rampant throughout the federal agencies. I'm about to conclude. For over 40 years, we have been implementing these major federal environmental laws. We've learned a great deal. A whole body of environmental science has developed. Now I think it's time is to make sure that it is strong, that the strength of the science is proportionate to the magnitude of the impacts. Thank you.